Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. Alright, I'm going to be honest with you. It seems like I kicked a bit of a hornet's nest recently with a video about summary judgment motions. I did not understand the extent to which folks do not understand summary judgment. So, we're going to do a little bit of a grab bag and try to answer a couple of different questions. One is a multi-part question, getting into summary judgment, because I'm getting a lot of calls about this, and it's like super off the wall stuff like, I'm a plaintiff and I'm going to file summary judgment and I'm going to win because my case is without question. It's like, okay, well, your case is two people in an elevator and one of you says the other said something horrible. Sounds like it's nothing but question, right? Like the jury, everyone but you and the person you were with, all have to decide who we believe, right? You say one thing, they say, nah, never happened. And we gotta figure out who we believe. Guess what? That's not summary judgment fodder. That's not gonna happen, right? And I'm not referring to any actual person there. I'm just that's like a facetious joke of like somebody I talked to with no identifying characteristics anyway, just like not grasping that not really grasping what summary judgment was. So let's start there. This isn't even a question. This is just a little bit of background. I urge you go check out our summary judgment playlist. I think we actually have two for some reason. There's a lot of videos that we have that define summary judgment and get into the standards more in depth than what we're going to do right here, right now. We're going to provide a real super quick idea of what summary judgment is and how it differs from motion to dismiss and what the standard in summary judgment is, and then we're going to get into these questions. All right, so the best way to think of summary judgment is a motion to end a case under the theory that we don't need a trial because there is no question of fact, right? A judge, a jury, an arbitrator, they're going to decide fact. They're going to decide what happened, or at least what they believe happened in a case. That's why they're called the finder of fact, right? And again, that could be a judge, a jury, or an arbitrator, whoever's empowered in a given situation to decide what they believe happened and have their decision stick for the purposes of an award, a decision, right? And that is the standard, really, for summary judgment. If you're seeking summary judgment, you are arguing, hey, there's no question of fact on this particular topic. Judge, you should decide this particular topic for us, or the case as a whole, for our side, for our benefit, because there's no question of fact, and we have proven what already happened, and a reasonable jury couldn't really differ with that. It is, or a reasonable finder of fact, judge, jury, arbitrator, whoever it is, could not differ with that, right? That is what you're arguing if you're arguing for summary judgment. If that sounds to you, to your ears, like a crazy high standard, you're correct. Very perceptive of you. Well, and I'm not actually being funny here. Like, well done. That you're grasping something that apparently many people, including many young attorneys, do not understand. The standard for summary judgment, the standard to be granted summary judgment on your case, is incredibly high. So keep that in mind when you call up an attorney who isn't even your attorney. Maybe his name is Vince White. I don't know. You're like, Vince, my attorney won't make a summary judgment motion on my behalf. I'm a plaintiff, and I want to file for summary judgment, and I think I should fire my attorney. What do you think? I'm like, I think you should talk to your attorney. I'm not your attorney. Call the attorney you're paying, first off. But second off, sounds like there's a lot of questions of fact in your case based on the 5-minute summary you decided to give me, which I did not even really consent to. But fine, we're done. We listened to it. So now Yeah, sounds like a lot of questions of fact. So, no, I think I agree with your attorney that making a summary judgment motion might not make sense. Now, there's another side of summary judgment. You might not be the one making the summary judgment motion. You might be the one opposing it. This is more common for plaintiffs. In part, this is more common for plaintiffs for two reasons. One, plaintiffs bear the burden of evidence on most of their claims. You can argue on a retaliation claim. They don't. But generally speaking, in discrimination and sexual harassment claims, the plaintiff bears the burden of evidence. And so when they argue for summary judgment, they're arguing, hey, there's no question of fact. I have met my burden in terms of evidence, and it is unquestionable. A reasonable jury could not disagree. A reasonable judge or arbitrator must concur with me that I've been victorious just on the evidence presented so far. It is inconceivable that the finder of fact would disagree. So I should be granted my claims in summary judgment. That's really effing hard. It's very difficult, right? When you're opposing that, though, as a plaintiff, you don't carry the burden of evidence. All you really have to say is, hey, there's some questions of fact left. Like, we need to go to trial to have these questions of fact aired out, heard by the jury, and decided. Listen, you might say that so-and-so could not possibly have discriminated against me because so-and-so was in Guadalajara at the time. But I happen to know so-and-so has a twin, and I don't know which one of those motherfuckers was in Guadalajara. So I think it's a question of fact. And I'll tell you, as outlandish as it seems, well done. I think you've just introduced a question of fact, right? It's a much easier thing to do, to just say, hey, we got questions of fact. We got questions of fact. We need to have this tried. We need heard by a finder of fact, right? That the odds of you successfully opposing summary judgment are substantially higher than the odds of you seeking and being granted summary judgment. Almost always. Now, keep in mind, there's a second reason why summary judgment motions are generally made by defendants. Their attorneys bill by the hour, usually. And summary judgment motions can take many, many, many attorney hours because they are girthy endeavors. They take a lot of time, a lot of effort. You got to cite to a great deal of evidence. You're essentially saying, listen, I made this case so airtight, it fits together so well, you actually couldn't disagree with me. Judge, jury, arbitrator could not disagree with me. You know how long it takes to build that kind of argument in just the papers? Just the summary judgment motion that you're making? Tens upon tens upon tens of attorney hours, maybe hundreds, depending on the case. Truly, sincerely. And correspondingly, let's break out my calculator here. If you're billing $1,500 an hour, and let's say hypothetically it's light. You're just gonna do 30 attorney hours in your summary judgment motion. Well, somebody just made $45,000 to file that summary judgment motion. I think you can tell why there's a second reason why defense counsel makes summary judgment motions. They're eager to do so, even if they're not all that sure they're going to be successful. Now, in contrast, the plaintiff's attorney, who thinks it's very unlikely that she or he will be successful in seeking summary judgment, when their client comes to them and says, I think we should file summary judgment, they might be very polite to their client, but in the back of their head they're thinking, shut your GD mouth, you effing moron. There is not a chance in hell that you are getting granted summary judgment on this case, and there is not a chance in hell that I'm giving up a week or two of my life to make this stupid motion that you are definitely not going to win. Just pissing away money and hours. because you're an asshole and you don't understand the standard. And I would hope they're not saying that to their client, and certainly that's not how I think about my clients. But I'll tell you right now, plenty of attorneys out there are going to think exactly that. They're hopefully going to sit down with you and be like, well, actually, I don't think summary judgment's a great option for us. Here's why. There's a lot of questions of fact that probably have to go before a jury here. And realistically, we don't have great arguments that I think would help us to win at summary judgment. And sometimes clients will hear that and they'll say, I hear you, associate attorney at the firm I hired. I hear you. But I also secretly don't give an F about you. So do the motion because I want the motion. And a plaintiff side firm is going to say, oh, okay. We're going to stop calling you back for a little while because this is dumb. You're being dumb. You're doing dumb things. And maybe you can't understand because this isn't your job. And we get that. And that's obviously not the correct reaction, right? The correct reaction is, okay, all right, I see you still don't get it. Let's start over. Let's go back to plaintiff's law school and let's discuss what you have to prove to win at summary judgment. And then let's apply that to your case and be very clear about why that's not going to happen here, right? And in fact, this video should be thought of as a resource for other firms. By all means, use it. If you don't want your client to get mad at you, make me your villain. Make me your bad guy. Play my video in which I berate your plaintiff, not my plaintiff. I respect my plaintiffs. I give my plaintiffs a great deal of my time, as do all the attorneys here. But I am perfectly happy to patronize the ever-living hoo-ha out of yours. So, stupid plaintiff at another firm. They're not going to do summary judgment motion for you because nobody thinks it's going to win. And the only reason you think it's going to win is because you don't do this for a living and you don't know what you're talking about. You're welcome. Now, those are the two reasons why, generally, the defense side makes the motions for summary judgment in our field. Don't get me wrong. We've made summary judgment motions for our clients, and we've been successful. And that is a great day. Trust me, it really is. Still need to have a damages hearing. Just because you win at summary judgment doesn't mean you're not going to have some semblance of a hearing. You're still going to have to go to court and talk about how much you win. But it's great to know you won, right? It's great to know you did such a good job in discovery that, boom, we don't need a trial anymore. That's a great day. It just doesn't come along that often. And frankly, the overlap between the clients who want you to file summary judgment motions and the clients who definitely should not file summary judgment is very close to 100%. I'll tell you this. I have never, ever once approached a client and been like, hey, I know it's wild, but I think we should make summary judgment here. We're going to get drafting on it. And had that be a client who had asked me previously to file summary judgment. I don't know why that is. Perhaps that's just happenstance. But often, there is no correlation between the strength of a case and a client's deep desire to file for summary judgment. Almost no correlation at all, and certainly no causation. Now, we're going a little bit long, but let's get to the questions. And all of this here is not aimed at anyone. It is not in response to these questions. These are good, insightful questions, and the answers to these questions will help people, and that's why I'm answering them. And I appreciate you for asking these questions. All right? Let's start. Let's find it. Okay. First question is from YouTube user Dallas Bread. Is a summary judgment motion normally a bluff tactic, asking for an amigo? No. A summary judgment motion is never a bluff tactic. Now, what could be a bluff tactic is saying, listen, I think we're going to win this in summary judgment. I'm gonna make a summary judgment motion. Yes, bluff tactic all the time. All the time. Excuse me. So there's tons and tons and tons of defense attorneys who will utter those phrases. You know you're not getting past summary judgment. Take the 30 grand. Okay. Well, listen, you just got to know your case and know if it's getting past summary judgment or not, right? You got to know the standard for summary judgment. Apply the facts of your case. Say, hey, are there questions of fact? Do I think I'm going to need a trial on this? Great. I don't need to worry about that ridiculous statement. And have a conversation with your attorney about that, right? It's not a great bluff tactic, but many, many, many defense attorneys try it. That statement is different than someone actually making a summary judgment motion, which is what you're asking about, right? Is summary judgment normally a bluff tactic? I assume you mean actually the motion for summary judgment. It is not, because someone spent tens upon tens, maybe 100 or more hours on that motion. So they're making the motion because they think it's non-frivolous, they wanted to bill a ton of hours, and they think they might knock out all or some of your claims. This is an important concept. Summary judgment does not have to be granted across the board. It does not have to dispose of the entirety of your case. Summary judgment can knock out some of the claims in a case when it's made against you. Or, in contrast, if you, the plaintiff, are the one making summary judgment, you could win some of the claims in your case, but not all, and still need a trial for those other additional claims. And partial success in a summary judgment motion is awesome for whoever gets it. So if someone's spending tens upon tens or maybe 100 or more hours on a summary judgment motion, you should be confident it's not a bluff. You should be confident that they thought they might get something knocked out. Them getting something knocked out of your case is not the end of the world. This is why we bring multiple claims, right? You have often a spread of claims, just like in Star Trek, where they have a spread of torpedoes. You don't know where the opposing spaceship's going to be, so you shoot a broad spread of torpedoes to try to hit the spaceship wherever it might end up. Here, too, in litigation, you bring a broad spread of claims, because sometimes discovery is going to foobar some of your claims, right? Listen, sometimes you bring a case and you're like, oh, I think that, I don't know, just think of something, I don't know. I think this person hates Irish people. And then in discovery, you learn they joined the Sons of Ireland, and they went every single week, and they travel to Ireland every month, and they are a shareholder in Air Limerick, and they have as their banner St. Patrick driving the snakes from the Emerald Isle. They occasionally give speeches about how much they love the Irish people, whether those are the Irish diaspora, the world at large, or those who still remain in Ireland. Anyone who survived Cromwell's famine, they are passionate in their support of. And I'll tell you right now, that claim's probably dead. That's a real good claim for somebody to get dismissed on summary judgment, because you're like, that person hates the Irish folk. And then you get the discovery on that, and not even you think that anymore. Well, that claim's probably dead. However, you might have retaliation claims or other claims that remain very much alive and survive summary judgment and go to trial and can win you money, right? So you have a spread of claims. So it's not the end of the world if you have one of your claims dismissed, or more, right? It's the same pool of damages for most of the claims in our field, so don't sweat it so much. Listen, if your strongest claim gets dismissed, that's concerning, because now you're going to trial on what you yourself perceive to be weaker claims. Don't love that. It happens. And you might think, well, I've got a bit of an uphill battle on this trial now. If you're the trial attorney there, and you probably do, right? If you're estimating your own chances to have gone down because of what happened in summary judgment, there is a decent chance that you are correct. But it doesn't mean you're going to lose. It means you need to get more creative, work harder, and try to do everything you can to remove risk and add value at the trial. So, Dallas Bread, which is a great username, by the way. I hope this answers your question. Let us move on to the next question about summary judgment. Let me find it. Uh-oh. We've lost it. Where is it? All right. This is YouTube user Brian Masawi, who says, "Hi Vincent, please respond if you could." I could and I can. And in fact, I am. What if the defendant attorney confirms that she is not going to file a motion for summary judgment? Okay, that's great news. So, defense counsel believes that a motion to summary judgment would not have merit if they're not filing it. Or, conversely, she might believe that the merit to that motion is so low that she had to correctly advise her client that maybe they shouldn't make the motion, and the client said, yeah, I don't want to pay the 50 grand that it might cost you to make this motion, so don't make the motion. Either way, that's good news for you. Your case is in a compelling enough state right now that defense counsel's like, yeah, we got questions of fact. We are going to trial. Fantastic news. Great news. Super great. The question goes on. What would be the consequences of a plaintiff filing for summary judgment? Well, you win or you lose. Or you partially win, and you still go to trial on some other claims. Those are the consequences. It should be noted that the case is a retaliation case and is very strong. It does sound very strong. The question of fact is sufficiently in existence that defense counsel seems to agree with you. There's strength to your case, and she does not think summary judgment has merit here. Oh, this is interesting. However, the defendant's attorney is a new attorney and stated that she has no time to file a motion of summary judgment. Okay. Now listen, that could be true, but let me address that. There's a decent chance that's bullshit. Here's why. That defendant attorney, that defense attorney, not the defendant's defense attorney, can be a new attorney all she wants. But she probably works at a firm if she's in employment defense. And that firm, if they thought the motion had merit, would assign that motion to another associate. Because again, that firm wants that 30, 40, 50 grand for filing the motion if it has merit. So for this defense attorney to be like, I'm not going to file it because I don't have the time, bullshit. Now, go a step further. Let's say you have the very, very rare solo practitioner who's working by his or herself as a defense attorney. Incredibly rare. They exist. They're incredibly rare for a variety of reasons, including it's just hard to defend cases by yourself. Well, I'll tell you right now, if I was a defense attorney and I was a solo practitioner and I had a client who paid their bills and I thought a summary judgment motion had merit, but I didn't have the time to write it, well, I assure you, I'd be throwing 5 contractors who are admitted to law in the state I'm practicing in to write that motion. And I would be billing for it. And I would edit it and go over it. And it would be the best damn motion with the most time spent that you ever done seen. And then go to my client and say, we did a great motion. I think it's going to be so good. Here's that bill for $50K. Pay up today. Right? So I call just massive piles of bullpucky on that statement that I just don't have the time to do summary judgment. I'm not going to do it. Nah, not a thing. Not a thing at all. Okay? Anyways, I hope this conversation about summary judgment helps you in some way to figure out what's going on here, to understand the lay of the land. I think we need some more on summary judgment. Maybe not. Maybe I'm wrong. Maybe I've addressed everything here today. But with the volume of stuff that I kicked up by doing that previous, 2-3 weeks ago, summary judgment video, I get the sense that, nobody's talking about this, and the information for employment plaintiffs on this topic is minimal. So ask your questions below. Hit me up. Let me know what you don't know. Let me know what you do know. Let me know where you disagree, where you agree. Let me know why you think summary judgment makes sense in your case and your attorney is wrong. I would love to make videos about all of that because I want a playlist of videos that I can send to people being like, hey, stop calling me about summary judgment. You didn't hire me. I don't need to worry about your summary judgment. Here are all the answers that I will ever create about summary judgment. Here. I want to make this for you, in part because I want to help you. I also want to make it for you because I want you to stop calling me because I'm not your attorney. And I'm sad that you're mad at the person who is your attorney, but I suspect they're correct on this topic. I suspect they are correct that filing summary judgment would be a waste of time for you as a plaintiff, but I don't know your case, and I'm not going to know your case, because I'm not going to spend the time in your case because you didn't hire me, and that's okay. I'm glad you didn't hire me. I'm glad you have good, well, at least I hope you have good counsel. It sounds like you're having a falling out with counsel, but I hope that overall they're doing a great job, and this is a short-term blip in the radar. Bump in the road? Yeah, better. Bump in the road. As to the relationship between you and your counsel, and that attorney, I hope that they are fantastic, and they're getting ready for trial, and they're going to hopefully do amazing for you at trial. You're going to win tons of money and be vindicated and made whole to some extent, to the extent that money can make you whole, which is already pretty questionable, but is one of the conceits of our field. I hope this helped. If it did, like, subscribe, comment down below. Please do comment down below. We need more questions on this topic. I would like to spend the week on this topic. I would like to do every single video for the next 7 days on this topic until we have answered every conceivable question that the group mind of the entirety of YouTube could generate in this field. That would make me happy. If these videos help you, please share them. Helps our channel to grow. And we're on our way to almost 91,000 subscribers already. It's moving quick. And we're going to hit 100K, and I'm going to get a plaque, and I'm going to put it on the wall right behind me, and I'm going to be so happy. Because I'm an old man. I don't really have anything left to live for besides that plaque. Take care, everybody.